All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in ceremonial session. Let all who have cause to plead draw near. Give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good afternoon and welcome to the Florida Supreme Court. Today we will be taking up the case of Palm Coast University Board of Trustees versus Alex Ross, number 23-2087. Whenever you're ready.
Good afternoon, Chief Justice Muniz, Honorable Justices, and may it please the Court. My name is Ethan Williams. I will be arguing for the petitioner today on whether the motion to dismiss filed by the Palm Coast University Board of Trustees should have been granted, where the complaint and attachments thereto failed to state a cause of action for breach of contract. We respectfully ask this Court to reverse the lower court's decision and dismiss this case with prejudice on the account that the trial court erred in denying the petitioner's motion to dismiss. The facts of this case are simple. The respondent, Alex Ross, was a student at Palm Coast University from 2019 until 2023. Upon acceptance into the school, Mr. Ross signed the Palm Coast University student contract, in which he agreed to abide by all university policies and regulations set forth in the student handbook. Furthermore, he agreed that the university has the right to expel students for academic dishonesty, and the Board of Trustees makes that final decision on any found violations. Now, in 2023, Mr. Ross was assigned to write a final paper for his marketing class. Upon submission, however, his professor accused him of using artificial intelligence to write his essay, which is a form of academic dishonesty. Mr. Ross went in front of an academic advisory committee, which concluded that he had used AI to write his final paper, and that decision was confirmed by the PCU Board of Trustees.
Can I ask you a question about that? So is the breach of contract allegedly that an incorrect decision was made about whether there was plagiarism, or is it about the process that was followed by the school in determining whether there had been plagiarism?
Yes, Your Honor. The opposing counsel will tell you that the alleged cause of action in breach of contract is the failure on the school to follow procedures to expel a student. They brought this on terms of a plagiarism policy that they attached to their complaint along with the student contract. I'm here to tell you that that plagiarism policy, the process in that plagiarism policy wasn't necessary for the school to have to expel a student, and that the expulsion, the clear language of the student contract gives the expulsion to the university as a whole, and the board, being a part of the university, then has the right to expel a student regardless of the process outlined in the plagiarism policy. The plagiarism policy itself was cherry-picked out of the student handbook, which was not attached to the complaint. And the student handbook, they used this plagiarism policy to try to sidestep the plain language of the student contract.
I'm not sure what we should make about the whole, maybe you can help me decide. The briefing and the decision below spend, I think, an inordinate amount of time on the question of whether or not the handbook is in fact incorporated by reference. This is a very technical kind of debate. What's the argument that we shouldn't just accept that because it's referenced in a document that is clearly attached, that just, is part and parcel of the record? What use do you want to make of the fact that perhaps there's a technical argument that it wasn't incorporated by reference? Are you here to argue one way or another on that this case should turn on it?
Yes, Your Honor. It is our stance that the student handbook, because that is the document referenced in the student contract that was agreed to by both parties initially, is necessary for a breach of contract to be proven on the petitioner's part. The student handbook not being attached to the complaint then doesn't prove sufficient facts to show that the board committed a cause of action. So even though the respondent may have attached a part of it in the plagiarism policy and alleged that that plagiarism policy was a part of the student handbook, the plagiarism policy itself never...
So why isn't the right answer then just to remand with instructions to dismiss without prejudice? Why isn't that the right answer?
Because, Your Honor, the student contract that was originally assigned and agreed to by both parties gives the right to the university to expel a student. So when a student disagrees or disobeys, I should say, the student handbook and the policies set forth, because the student contract aligns that all policies are in the student handbook, when a student breaches that contract by not following the policies in the student handbook, such as using AI to write their final paper, the board, outlined in the student contract, has the right to then expel the student, regardless of the plagiarism policy or if the student handbook is attached or not. The board still has the right to expel a student because even as the record shows, the Academic Advisory Committee and Board of Trustees found him guilty of using artificial intelligence.
So it's your argument that even if the procedure was not properly followed, that it doesn't matter because they had the ultimate discretion to expel him?
Yes, Your Honor, and we use the case Florida Bar versus Green to back up the fact that procedures don't necessarily have to always be followed, every detail of procedure to be followed, if the ultimate outcome of the procedure is the same, if a step was or was not conducted. In that case, there was a Florida lawyer, Green, was accused of 5 charges, and all 5 of those charges disobeyed rules of the Florida Bar. A referee was assigned to then evaluate those misconducts, and despite certain aspects of the procedure, not all misconducts were looked into, because Green admitted and was found to have committed at least 2 of those misconducts. And therefore, despite not all conducts being looked into, the procedure still, it didn't matter, because the initial outcome was that he was then suspended from the bar because he didn't meet the requirements. He failed to abide by the policies. So even if the plagiarism policy outlines that, because opposing counsel will tell you that the dean must conduct not must, but the language in the plagiarism policy says they will conduct an informal hearing and include a sanction. Despite the sanction, despite if the dean did or did not conduct a hearing, Mr. Ross did go to an academic advisory committee outlined in the plagiarism policy. The plagiarism policy says that the academic advisory committee will review all decisions at the request of the student, and that decision has to be approved by the Board of Trustees. And upon that approval, then they can expel a student.
So is the procedure that happens, so there's supposed to be 3 steps, right? And here there were only 2. Is that second step supposed to be the same? Does it give the student the same opportunity to make their case as they would have had in the first step if that had happened? Or is it, because it sounded more like it was supposed to be an appeal where you're not necessarily trying to establish facts in the first instance?
Yes, Your Honor. The plagiarism policy outlines that first step where it goes to the dean. It describes it as an informal hearing. So it is not an official hearing or official accusing of the student. It's a small, simple analysis of, okay, what happened? Did you or did you not break the policy? And if the dean decides, yes, I believe that you did, then they could say, all right, we'll expel you for this. And then, yes, like you said, it could go to the academic advisory committee for an appeal if the student feels like they were wrongfully accused. However, because the academic advisory committee is that second step, and Alex Ross did go to that committee, it gave him a chance to plead his case. It gave him a chance to plead his case and describe all the facts again. And again, the academic advisory committee also found that he cheated. So regardless of if the dean saw it or not, the academic advisory committee is the overarching power authority in the university.
Is the difference between the bar cases and in this case is the bar cases are more of a due process issue and this is more of a breach of contract issue? So why should we not see that as a distinction here? Because the allegation is that because you failed to follow these specific steps, you deprive me of a right I'm entitled to under a contract, versus in bar cases, you know, there's a concern that we just want to make sure they receive the process they were due.
Well, Your Honor, that is what the initial argument in the case was. That's what it was brought to trial with, was that due process was not followed because the plagiarism policy outlines a procedure that the school has to go through or will go through in this circumstance. However, it is our stance that regardless of that procedure, even if that is argued, none of that doesn't necessarily matter, because the student handbook is incorporated in the student contract, but because the suit is brought in terms of plagiarism policy, and the student contract doesn't specifically reference the plagiarism policy, there isn't a breach of contract, because the agreed upon contract was the student contract, because that's the only contract that was signed, and therefore that's the governing language that should be looked at in this case. And as such, by giving power to the plagiarism policy, the trial court erred in examining the actual cause of action here, which at the end of the day was Mr. Ross not meeting the policies in the student handbook and cheating. And as such, we respectfully ask this court to reverse the lower decision and dismiss with prejudice. If there's no further questions, I give to my co-counsel.
Thank you.
May it please the court. Good afternoon, Chief Justice Munoz and honorable justices. My name is Zoe Priolo for the petitioner, and I'll be discussing whether the trial court abused its discretion upon admitting Mr. Gray's testimony, which addressed linguistics as an expert in artificial intelligence. It's relevant to know that during this trial, the respondent called Cameron Gray an expert in artificial intelligence to testify. The petitioner objected to the testimony on the basis that testimony on linguistics was outside of the scope of Mr. Gray's expertise. That objection was then overruled. In lieu of a dismissal we asked for by my co-counsel, we asked that the case is remanded with directions for the court to limit Mr. Gray's testimony to artificial intelligence, on the basis that this was an abuse of discretion, a harmful error was made, and that there was no foundation laid for testimony of linguistics. Now, first of all, this is an abuse of discretion under the criteria of the case of Robertson v. Cherry, which quotes DeLeslie v. Crane. These two cases say that a trial court holds the right to broad discretion absent of a clear error. Well, in this case, there is a clear error, and that was that Mr. Gray was not proffered as an expert in linguistics.
I'm sorry to interrupt you. Can you explain to us what the actual testimony was? And because it sounds like some of it definitely was about AI, and I know there's an argument that some of it then sort of morphed over into linguistics. Could you just explain to us what the testimony was and sort of which aspects of it fit into which bucket?
Yes, Your Honor. So the objected mentions were one of comparing a previous paper by Mr. Ross to the paper that was in question. Another one of the objected mentions was when asked what aspects of linguistics were used in his analysis of those papers. And the last one was a description of vocabulary between artificial intelligence and non-human writing. We would argue that those three instances had more to do with linguistic expertise than artificial intelligence expertise, and therefore could not be within Mr. Gray's scope of expertise. Now, that said, the two fields may overlap. However, that does not necessarily mean...
Do you want to address, just, from an initial preservation perspective, do you want to address, you mentioned the initial, or the objection, but do you want to respond to the argument in the respondent's brief that at that point Mr. Gray had already testified without objection that linguistics was part of his methodology, that his credentials had already been proffered, including his degree? What's your response to that argument?
Yes, Your Honor. So we would argue that a proper foundation for artificial intelligence was laid. However, the proper foundation for the specific testimony of language comparing two papers to each other was not. While it's true there was a degree that was brought out, a degree in applied linguistics, it was never elaborated on what that degree means or why it would be relevant in this case. And simply having a degree would not make Mr. Gray an expert in the field of linguistics. Additionally, the expert testimony must have been based in facts or evidence within knowledge pursuant to Anderson, Moody versus Wilson. Now, further information that would demonstrate possible knowledge was just not presented when proffering Mr. Gray as an expert in linguistics. If the respondent wished to include testimony about linguistics, the proper foundation should have been laid, showing Mr. Gray's experience in that specific field. Additionally, Mr. Gray failed to connect the fact that artificial intelligence and linguistics connect. While it's true he talked about holistic approach and foundation, or laid a foundation of how it included linguistics, Mr. Gray's background was in artificial intelligence and not linguistics. It was never established that experts in artificial intelligence could conduct that holistic approach. We see once again a very similar situation in Anderson versus Moody, where the expert failed to establish that a life care expert can perform medical exams. Similarly, Mr. Gray never established how an artificial intelligence expert could perform the holistic approach exam.
What else, I mean, what was missing? He said that he's had a degree, he said that, you know, he can discern from papers that artificial intelligence uses clunkier language and, you know, sentence structure would be consistent if a human was writing it. What else do you expect from him?
Yes, Your Honor. So the missing information would have been more information on that degree, information about how it's relevant, how he uses it, possible work experience in that specific field. It was brought up that Mr. Gray had work experience within the software of GPT-0, which was the software detection company used. However, it was never brought up the experience within the specific detection and language of that company. So it was never really explained that he had that experience. And additionally, we would argue that because this testimony was given and he was not proffered, this would be a harmful error. The testimony exceeded the scope of the matters. Testimony on linguistics on its own, the comparison of the two papers, was not what Mr. Gray was called to testify about. In a similar case of Druss versus Garcia, an expert was called to testify about a standard of care, or in this case, artificial intelligence. That expert then went on to discuss causes of neurological injury, or in this case, linguistics. This was objected to, and the court ruled that because it exceeded the scope of the matters, it was inadmissible. While yes, neurological injury had to do with the case at hand, it was not what the expert of that case was called to testify about. While it's true artificial intelligence writing includes ideas about writing, it's not what Mr. Gray was called to testify about. Now, in this case, we would argue that this was harmful as it caused a big impact on the jurors. It aided in providing information to conclude the ultimate question, as this testimony bolstered the idea that Alex Ross had not used artificial intelligence. In the case of Anderson, Moody versus Wilson, the expert testimony was deemed inadmissible, the case was remanded, and damages were reversed of the amount of $341,000.
How much did the testimony add to what the jurors would have been able to see for themselves? I mean, it sounds like the AI stuff was kind of technical, but the comparison of the two writings is kind of common sense.
Yes, Your Honor. So we would argue that because this testimony was given by an expert witness, it held more weight than what the average person may have been able to say. And that was the error of the court, allowing this testimony of language to be portrayed as an expert testimony, when in reality it most likely or definitely was not. This gave undue weight to the testimony, causing it to be weighed more heavily by the jury, which was the error and which is what caused the harm. Without this error testimony, the jury may not have found sufficient evidence clearing Ross of artificial intelligence, and therefore would have found a sufficient evidence of a breach of contract, which would change the results of this case completely. Now, once again, I would like to go back to the idea that these two fields are very similar. However, this does not necessarily mean that Mr. Gray had the right to testify in that overlapping field.
But isn't your argument more of a matter of degree than category? So you're saying that we just needed a little bit more information from him about why he was trained in linguistics rather than the bare minimum that he provided. And
Yes,
it seems like in the cases you rely on, there was a complete absence of any sort of indication to the qualifications. So why isn't this different from those cases where there was just an absence of qualifications?
This is different from those cases, as this was a harmful error, and the absence of those qualifications can lead to undue weight given to the testimony. As I explained previously, by showing this testimony as an expert testimony of linguistics, it gave undue weight, when in reality, Mr. Gray, on his direct examination, never gave those qualifications and never gave that testimony would hold that weight. Now, I see my time is running short, so the petitioner would like to conclude in saying that this case is a clear error and clear abuse of discretion under the criteria of Robertson versus Cherry and the precedent of State versus Fitzpatrick. This was a harmful error under the rulings of Druss versus Garcia and Anderson Moody versus Wilson, and there was no proper legal foundation laid for the linguistic expert testimony under Anderson Moody versus Wilson. It is for these reasons that we ask the court today to deny the 7th District Court of Appeals decision and rule that Mr. Gray's testimony was inadmissible. Thank you.
Thank you.
Good afternoon, Mr. Chief Justice, honorable justices, and may it please the court. My name is Jake Sang. Today, along with my co-counsel Matthew Rodriguez, we have the pleasure of representing the respondent in this matter, Alex Ross. Of the 2 issues before the court today, I will be addressing issue 1, on whether the motion to dismiss filed by the Board of Trustees should have been granted where the complaint and attachments thereto failed to state a cause of action for breach of contract. We ask this court to uphold the decision of the lower court in denying that motion to dismiss for 2 reasons. Firstly, because the complaint and attachments did properly state a cause of action for breach of contract, and secondly, because even if the complaint was defective, the petitioner was not prejudiced by any error. The standard review in this case, pursuant to the Florida Bar v. Green, is de novo. Further, the review of a motion to dismiss is very favorable to the respondent, to the effect that courts are required to assume all facts from the complaint and the pleadings of the complaint as true, while construing all reasonable inferences in favor of the non-moving party, in this case, the respondent. That's pursuant to Air Quality Experts Corporations versus Family Security Insurance. With that in mind, the first reason we ask this honorable court to uphold the decision of the lower court is because the complaint and attachments did properly allege a cause of action against the Palm Coast University. The first thing petitioner says is that the failure to attach the student handbook was a deficiency in the complaint. However, Rule 1.130 of the Florida Rules of Civil Procedure clearly dictate that for the purpose of reviewing a motion to dismiss, any exhibits used to review that motion can be either attached or impliedly incorporated by reference into the text of the complaint or any of its attachments. In the instant case, page 2 of the record reflects that there is a line in the student contract that specifically references the student handbook. Pursuant to one called Property Services versus Security First Insurance, this reference is enough to use that document for the purpose of review. In that one call case, there was a homeowner's policy that was used by the court for reviewing the motion to dismiss simply because it was referenced by one of the attachments to the complaint. And we believe it is a very similar instance here.
So can you just clarify for us, what is the alleged breach of contract? Is it all just the process?
Yes, Your Honor. The alleged breach of contract in this case is that the specific policy that is clearly stated out in the plain text of the plagiarism policy, specifically the fact that the dean must first conduct an informal review, was not followed by Palm Coast University. And thus, this is a very clear breach of contract. Now, petitioner argues that there might have been some clauses that were unknown in the student handbook due to not attaching it. However, we would say 2 things to this. The first thing we would say is that the student handbook was directly written by Palm Coast University and was thus in their custody and control. In addition, the record does not reflect that there were any clauses within the student handbook that would allow Palm Coast University to subvert the clauses of the plagiarism policy and go around those clauses, and as a result, be allowed to expel Alex Ross under some alternative procedure.
How were you harmed
Your Honor,
by the failure of that first step happening?
Yes, Your Honor. We understand the petitioner's reliance on the case Florida Bar versus Green. They argue that the harm would have occurred in either way, since the result would have been the same in the hearing. However, we would distinguish this case from Florida Bar versus Green in 2 ways. Firstly, as Justice Sasso rightfully points out, this is specifically a breach of contract case, and the fact that the specific terms of the contract, which are required to be followed by all parties, were not followed, is distinct from the Florida Bar case, in which case it was simply a question of due process, which was ruled to have been followed. In addition, in that Florida Bar case, the reason why that initial probable cause finding was skipped over was because the defendant in that case already effectively pled guilty to all of the accusations he was accused of in that indictment. So in that instance, there would be no harm in skipping that initial step and just going straight to the disciplinary hearing. In this case, however, the explicit reason for the academic advisory committee's existence is for the student to appeal the decisions of the dean after he is directly informed of them. Specifically, page 2 of the record reflects that the dean is required to inform the student of what sanction he is placing for their alleged academic misconduct, as well as their right to appeal to the academic advisory committee. Because Alex Ross, pursuant to page 2 of the record, was immediately directed to that committee, he did not have time to collect any evidence in his defense or put together any sort of argument that might have been able to convince the Board of Trustees, or rather the Academic Advisory Committee, that he did not, in fact, that he was not, in fact, guilty of the academic dishonesty that he was accused of. And Chief Justice Muniz, that is the direct harm that we allege in this case, given the fact that Alex Ross was not given adequate time to prepare. In addition, we would like now to take the time to address the petitioner's argument about the fact that there might have been an alternative procedure that the school could have used to expel Alex Ross while going around the plagiarism policy. Now, even assuming this court does rule that that alternative procedure does exist, we would say this is at minimum an ambiguity in the contract. The fact that there are two conflicting procedures in the exact same contract that are supposed to dictate the circumstances over expulsion. And any ambiguity in the contract pursuant to Aqua Chile v. Williams must be construed against the drafter. In that case, that's Palm Coast University. In that Aqua Chile case, the Aqua Chile food supplier was relying on a clause in a Royal Caribbean contract saying that any lawsuits against Royal Caribbean must be in Miami-Dade County. And they extended that provision to all related parties. The court correctly ruled in that case that there was an ambiguity as to whether or not Aqua Chile was in fact a related party in that case, and as a result of that, correctly construed the text of that contract against Aqua Chile and allowed the case to proceed to trial. Similarly, in this case, the fact that there are two entirely conflicting procedures, hypothetically, according to the petitioner's argument, means that this is an inherent ambiguity in the contract. As a result, it must be construed against Palm Coast University, and the case should be allowed to proceed to trial.
Do you think there should be any obligation to show what type of evidence would have been admitted if there had been more time?
Yes, Your Honor. We believe that if there was, in fact, a provision in that student handbook that would allow the university, rather, to expel Alex Ross without the plagiarism policy, there was no facts in the record that would reflect any sort of the fact that the petitioner would actually bring this up at trial. There were no
I guess
facts.
what I'm asking is, so had the informal hearing gone forward, is there anything in the record to indicate what sort of evidence would have been admitted? You made the point earlier that he would have had more time to gather evidence. Is there anything in the record showing what would have been admitted and how that would have caused a different outcome?
Yes, Your Honor. The entire second issue before the court today is on this expert, Cameron Gray, that he called for the purpose of this lawsuit. If he had more adequate time to prepare, he might have been able to put his essay through a similar AI detector or call a similar expert in front of the Academic Advisory Committee in order to prove that he did not, in fact, use artificial intelligence to write the essay he was accused of writing with AI. And because of this failure to inform the student in that instance, he was unable to prepare any sort of defense against the allegations he was being accused of. And for that reason, there was a very clear harm against the student. And the second reason we would ask this honorable court to uphold the decision of the lower court is that there was no prejudice against the petitioner. So the correct remedy at the trial court level would have been a dismissal with the possibility to amend. If it is true that the deficiency in the the plaintiff's case is the fact that he failed to attach the student handbook, a simple amendment to the complaint, changing it to instead attach that handbook, would have been enough to cure that deficiency. In addition, the trial court, or the court ruled in Affordable Homes Inc. versus Devils Run Limited that there are only two situations in which a dismissal with prejudice, which is what the petitioner is asking for in the instant case, can occur, either when the amendment privilege has been abused or when any amendments made would be futile. The record does not reflect that any previous legal action was taken by Alex Ross against Palm Coast, so the amendment privilege was not abused. In addition,
if the right process had been followed, would that essentially insulate the school's decision from any kind of review?
Well, Your Honor, we believe that there might have been additional causes of action aside from that breach of contract action that was initially brought. This is very similar to this Affordable Homes Inc. versus Devils Run Limited case, where although the court properly struck down the complaint and granted the motion to dismiss, they improperly granted the motion to dismiss with prejudice, as the court ruled in that case that there were additional allegations that could have been made and additional causes of action that could have been made, such as estoppel or waiver. That meant that even if the first initial cause of action on breach of contract was ruled to have been completely invalid and negated by a term in the attachment, there were additional other causes of action, such as this estoppel or this waiver, that would have allowed the case to continue had the original breach of contract action been struck down. Similarly, in this case, Alex Ross could have alleged discrimination on the part of the school. He could have alleged the fact that the school's behavior made it very difficult for him to fulfill the circumstances of that contract. And as a result, there is nothing in the record to reflect that there weren't any if it wasn't impossible for Alex Ross to either allege additional facts that would help support his cause of action, or even if this original cause of action wasn't valid, there were no other additional causes of action. As a result, he could have either amended his complaint to include these additional facts or allege additional causes of action against Palm Coast University. As a result, the correct remedy would not have been a dismissal with prejudice, but rather a dismissal with the possibility to amend the complaint and allege these additional facts or causes of action aside from breach of contract. It is for these reasons that we respectfully ask this honorable court to uphold the decision of the lower court in denying the motion to dismiss. Thank you.
Thank you.
Mr. Chief Justice Muniz, honorable justices, and may it please the court. My co-counsel Jake Sang has already introduced me, but one more time, my name is Matthew Rodriguez, and I have the pleasure of representing the respondent in this matter, Alex Ross. Since Mr. Sang has already touched on issue 1, I'll be addressing issue 2. That is whether Mr. Gray, the respondent's expert in artificial intelligence, should have been permitted to testify over objection to opinions and conclusions concerning the field of linguistics. We'll be asking this court to uphold the decision of the lower court and affirm for the following 3 reasons. First, the petitioner did not properly preserve this issue for appeal. Secondly, pursuant to Florida Statute 9702, the trial court did not abuse its discretion in admitting Mr. Gray's testimony. And finally, even if the trial court erred in allowing the testimony, it did not produce harmful error. To begin, in Daubert v. Merrill Dow Pharmaceuticals, the United States Supreme Court ruled that the trial judge is burdened with a certain gatekeeping function to ensure that expert testimony rests on a reliable foundation. But it was this honorable court in Delisle v. Crane Co. which I correctly identified that the gatekeeper role under Daubert is not intended to supplant the adversary system, which is to say that the petitioner still had a duty to preserve any issue that they intended to bring before the court on appeal, which is something that, to Justice Sasso's point, the petitioner simply has failed to do.
Well, I mean, can you flesh that out some? Because it seems like the petitioner did object, or counsel below did object, but that your argument is that because there had already been evidence admitted through proffer, that the objection was too late, essentially. So can you flesh out that argument more, a little bit factually?
Certainly, Justice Sasso. To be clear, while petitioner did make numerous objections to Mr. Gray's testimony, it is more of an issue of timing rather than it is to the multitude of objections. During the proffer of Mr. Gray's credentials, per the record on page 7, he made it clear that he had a methodology, a holistic approach to artificial intelligence, and that that holistic approach included the field of linguistics. And so it was at that point during the proffer when Mr. Gray made it very clear that he intended to testify to linguistics as part of his approach to artificial intelligence that the petitioner should have objected in order to preserve the issue. The petitioner's objection only came when, before the jury, Mr. Gray finally testified to his conclusion and how his study of linguistics assisted him in coming to his conclusion that artificial intelligence was not used to write the paper. So we'd say petitioner has simply failed to make a contemporaneous and timely objection, and neither has petitioner addressed this argument during oral arguments so far.
So why does the contemporaneous nature of the objection matter so much here, given the fact that it is ultimately an expert testimony matter where it's not until, as you say, the opinions and conclusions find their way to the jury? Why other than just, I'm looking for more than just because the rule says so, why is the contemporaneous nature of the objection so important to you in this fact pattern?
Your Honor, the importance of a petitioner objecting, not just timely but also contemporaneously, is that it gives the trial court an early option to correct an issue before it's brought before appeal. If the petitioner does not object in a timely way, the trial court does not have the opportunity at that point to, at the first option, correct any sort of error that may occur. So during the proffer, had the petitioner objected, the trial judge, if in fact Mr. Gray's testimony wasn't inadmissible, would have had the opportunity to then rule that Mr. Gray should not testify to anything regarding linguistics. And in failing to make that contemporaneous objection, the petitioner simply did not grant the trial judge that opportunity. But if this court were to find that the petitioner did properly preserve the issue for appeal, we would still say that the testimony was not admitted as an abuse of discretion on behalf of the trial court. Now, Petitioner makes two clear arguments, one being that there was not sufficient foundation laid in the record as to Mr. Gray's linguistics expertise, and secondly, that Mr. Gray's testimony regarding linguistics was not sufficiently connected to his tenured field of artificial intelligence. And I'd like to answer both of those questions in tandem by directing the Court's attention to a case in the 5th DCA, specifically LaPera v. State. Now, the LaPera Court was tasked with determining whether a biomechanics expert could testify to opinions and conclusions regarding injury causation. And the LaPera Court asked two key questions in order to determine whether the biomechanics expert could have testified to that effect, considering that injury causation is typically considered within the domain of a medical expert. And so what the court in LaPera asked was, first, whether the biomechanics expert's opinions required independent medical expertise that the biomechanics expert did not have, and secondly, whether the biomechanics expert's opinions on injury causation fell within the tendered field of biomechanics. And if we were to apply a similar analysis in this case, this court should be asking whether Mr. Gray's opinions and conclusions in linguistics required independent linguistics expertise that Mr. Gray did not have, and secondly, whether the field of linguistics and his opinions and conclusions thereof, as connected to his tendered field of artificial intelligence, were sufficient. And we would answer both of those questions in favor of the respondent. Beginning with the first prong of LaPera, it's Petitioner's argument that the issue in the trial court was not that Mr. Gray was not sufficiently qualified, it was that he did not lay sufficient foundation to that effect, that he did not perhaps go into what he was required to do in order to get his degree, what sort of training he's done, and that was Petitioner's response to Justice Sasso's question. But I'd like to direct the court's attention.
Wasn't it also that he wasn't tendered for that specific purpose? I mean, what is your response to that argument, that he was tendered for this narrow purpose and he may have been able to render a broader opinion if he had been tendered for that purpose?
Well, Your Honor, we would have a twofold argument to that. First, that even if Mr. Gray had been improperly tendered, that would be a harmless error, given that if the case were to be remanded and Mr. Gray was sufficiently qualified, at the end of the day, Mr. Gray would just then be tendered by the directing attorney in the field of linguistics, and then the exact same conclusions would reach the ears of the jury. But secondly, and we'll touch on this more later when we get to the second prong of LaPera, that, in fact, Mr. Gray's opinions in linguistics were part and parcel of his opinions as an artificial intelligence expert. With regard to the argument that there was a lack of foundation, we would say that the factual distinction between LaPera and between the instant case is what cures this argument, specifically because the court in LaPera noted that the reason why the biomechanics expert could not give a very in-depth testimony about injury causation was the fact that the biomechanics expert did not have a medical degree. That was the bright line that the LaPera court identified. And here, we're on the other side of that bright line, effectively, because Mr. Gray has that linguistics degree, and he has that linguistics training that is necessary in order to obtain that degree. And so any other further qualifications that Mr. Gray could present during the proffer is not a matter of admissibility, but a matter of providing more credibility to the trial court. But it is that degree that was enough for the trial court to be situated to make a decision on the qualifications of Mr. Gray, and it was enough for the trial court to have not abused its discretion. If Petitioner wanted to go more into the exact credentials of Mr. Gray with regarding linguistics, that would be more of an issue of cross-examination rather than one of the admissibility of the evidence. So we'd say that's not an abuse on the part of the trial court. But secondly, with regards to the connection of the field of linguistics and artificial intelligence, and that goes to that point of how he was not tenured in artificial intelligence, his opinions and conclusions regarding linguistics were ultimately almost a manual execution of what his program does, GPT-0. Now, during the very beginning of his testimony in front of the jury, Mr. Gray testifies that he's created an artificial intelligence detection software called GPT-0. And that, per the record on page 4, that detection software is trained in order to, on vast data sets of academic writing of both human and AI text, and is trained to recognize patterns and structures unique to each source. So when Mr. Gray is looking directly through these papers for artifacts of artificial intelligence, when he's comparing two papers to see if he sees those artifacts in both or the similarity between the two, in effect, he's performing a manual analysis of what he has to have the expertise to do in order to code his program, GPT-0, to do the exact same thing. I'd like an analogous situation would be if you have the creator of a virus detection software. The creator of the virus detection software would need to be able to identify viruses in the code themselves in order to code the virus detection software to be able to identify them automatically. So that's what Mr. Gray is doing here. He's performing a manual analysis of what his program GPT-0 does. And it's because Mr. Gray...
If we disagree with you, though, how could this ever be harmless error? Seems like having an opinion from an expert on somewhat of an ultimate issue would be very persuasive. So how would you argue it's harmless?
Yes, Your Honor. We would concede the fact that Mr. Gray's opinion does go to the ultimate issue of the plaintiff's compliance in a breach of contract case per Affordable Homes Incorporated v. Devils Run Limited is an essential element of the breach of contract claim. However, we'd remind the court that if the case were to be remanded, ultimately, when it comes to the substantive difference in Mr. Gray's testimony, what would have happened to Petitioner's point is that Mr. Gray would then lay further foundation as to his linguistics expertise. Again, it's not the Petitioner's contention that Mr. Gray is not qualified in the field of linguistics. It's simply that he did not lay that foundation. So if this case were to be remanded, he would simply lay the foundation. He would perhaps be tenured in that field as well. And then the exact same testimony would reach the ears of the jury. To use Petitioner's case, Anderson, Moody v. Wilson, the court in that case found that the excluded testimony was harmful, partly because it went to the ultimate issue, but also because no reasonable jury, absent that testimony, would be able to find in favor of the appellant in that case. The issue being that in this case, should this case be remanded and the exact same testimony, exact same conclusions reach the ears of the jury, a reasonable jury would be able to make that exact same determination, and so the Petitioner has failed to show a showing of harmful error. And it's for those reasons we ask this court to uphold the decision of the lower court and affirm. Thank you.
Thank you.
Honorable Justices, I would like to point out the fact that we concede, yes, complaints and facts in that complaint should be made in favor of the plaintiff. However, we also would like to point out that outlined in Coleman and Skate Park, that regardless of facts, the plain language of contracts attached to a complaint should govern over anything that happened in the complaint. And the clear contract in this case is the student contract and the plagiarism policy, which both say that the university has the right to expel and gives the board the authority to do so. The board has more authority over the dean, so regardless of if the dean heard it or not, the board could expel because they had more authority over the dean in the long run. And opposing counsel saying even admits that the PCU plagiarism policy is under the university's control. So even if procedures outlined in the plagiarism policy weren't followed, if the university deems that they expelled a student based on academic misconduct, it is within their right to do so because they own that plagiarism policy. And any procedures outlined in it is just to help future people in that position to conduct it correctly. And so regardless of whether the dean saw it or not, the board made the final decision. And lastly, I'd like to address that the student agreed to the student contract to abide by all policies, not the board. The board outlined that these procedures are necessary, but the student ultimately agreed to follow the policies in the contract.
What was it that the board agreed to?
The board agreed to expelling students if found of academic misconduct, which in this case they did. And secondly, lastly, I'd like to address what Justice Sasso touched on, was that if no foundation is laid, and this is simple, and if no foundation is laid in the case, then an expert cannot give, I'm running out of time, just this final point real quick. The expert cannot give testimony on that case. And Cameron Gray, being an expert and being admitted as an expert in that case, his testimony has an overwhelming authority on the jury. And the jury, despite if it was in the conclusion or not, the jury heard it and thus made their conclusion based on it. And if he wasn't admitted as a linguistics expert, he cannot testify on linguistics. Regardless of if he has the qualifications, the foundation was not laid. According to State versus Fitzpatrick, if the foundation is not laid, the testimony cannot be admissible. And that's why the trial court erred on both accounts of failing to dismiss the case and allowing Mr. Gray's testimony. And therefore, we ask this court to reverse the decision and dismiss the case with prejudice. Thank you.
Thank you. And we'll be in recess for a few minutes and then be back.
All rise. The Florida Supreme Court is back in ceremonial session. Please be seated.
Okay, well, we're back to announce the winners, but before I say that, I just want to congratulate all of you. Everybody did a great job, super impressive. It's amazing how well prepared you all were, your mastery of the facts, the law, your ability to answer questions, your composure. All of you are way ahead of schedule, way ahead of where I would have been at your age. So congratulations, and thank you for putting so much effort into this. So it was a tough decision, but we decided that for the best team, we chose the Respondents Council. So congratulations. Okay. And then for the best oralist, all of you really honestly did a great job, but there's one of you in particular who stood out, and you reminded some of us of sort of a young version of one of the better advocates who appears before us on a regular basis. So Matthew Rodriguez, best oralist.
Yes.
Yes.
And also, let me say, too, congratulations to any of you who were coaches or parents or helped out. I know you're really proud of how the students did, and we really appreciate the amount of time and effort that you put into this. It's great for the future of the profession, and thank you very much for the effort.
Great job. Congratulations.
No, congratulations.